Good morning. I hope you're all keeping well. The aim of this session is to give you a brief introduction to criminal law based on chapter 18 of the AS Law textbook. Now, I'm going to start by quickly defining what a crime is. And a crime is simply any action of an individual that goes against the state. Most crimes are generally punishable either by a custodial sentence, such as imprisonment, or sometimes by a fine, but there are also other types of punishment that go with criminal offences. Your typical examples of criminal offences will be the most serious being murder, assaults and batteries and theft are all examples of criminal offences. Now, it's important to note that over the years, attitudes towards behaviour that constitutes criminal offences has changed. If we take, for example, homosexuality in 1885, it was an offence to engage in any homosexual behaviour. But attitudes have changed over the years, and in 1967, the age of consent was 21. And then in 1994 it moved to 18, and currently it is 16. So we see that society's attitudes towards certain behaviours that were initially classed as criminal offences have changed. It's also important to acknowledge the role of judges in creating criminal law. I think the most important thing to remember is that, generally speaking, if you remember what we did from chapter 3 of the English legal system, Parliament is the supreme lawmaking body. But as you would have read in chapter 18, sometimes judges make laws, and whether that's the right thing or not is up for debate, but we know that Parliament is, in the United Kingdom at least, the supreme lawmaking body. So cases such as DPP and Shaw and also R&R, one, DPP and Shaw, to do with conspiracy to corrupt public morals, wasn't an offence in any act of Parliament. It's an offence created by judges, and that, generally speaking, isn't the right thing in law. The offence under R&R of marital rape wasn't created by any act of Parliament at the time, and also meant that the defendant was punished retrospectively, which again raises concerns about how the law dealt with that particular instance. Now, another important point to appreciate is every criminal offence is divided mainly into two parts. And this particular point will form the foundation of your knowledge of criminal law. So for every offence, there will be what we call the actus reus, which is the guilty or wrongful act, and also the mens rea, which is the corresponding guilty mind. No doubt we will talk more about actus reus and mens rea when we have a look at chapter 19. But it's important to remember that in order for a defendant to be guilty of an offence, the prosecution must prove that the defendant committed the guilty act and the defendant had the corresponding mens rea. So to give you a quick example, if we take the offence of theft, now the first thing the prosecution would have to prove is that the defendant took something that belonged to another person. Now, when we have a look at theft in year 2, these seem very simple words, taking something belonging to another person, but there are deeper meanings and there are statutory authority that explain the word taking, or from section 1 the word used is appropriate. The other word is property. What is property? If you go into a field and take wild mushrooms, is that classed as property? So the point I need to emphasize here is when we talk about convicting the defendant of a criminal offence, the prosecution must show one, actus reus. So in theft, the defendant took an item belonging to another person. The other thing the prosecution must prove is the guilty mind, the mens rea, which means that the defendant thought about it, the defendant wanted to take property belonging to another, and the defendant in fact did take property belonging to another. So those two things, actus reus for theft, taking something belonging to another person, and the mens rea for theft, thinking about it, not being forced to do it, doing it voluntarily. So the mental element that goes into committing offences is referred to as the mens rea. No doubt we'll be talking a lot more about actus reus, the wrongful act, and mens rea, the guilty mind. The next thing we need to have a quick look at is we will also be dealing with particular types of offences called strict liability offences. And these simply require the prosecution to show that the defendant committed the wrongful act. There's no need to show that the defendant thought about committing the wrongful act. Typical examples will be speeding. So if you think that you're driving in a 30-mile-per-hour zone and in fact it's a 20-mile-per-hour zone and you do 25, when you think about it, you didn't mean to drive faster than 20 miles per hour. But in the eyes of the law, because speeding is what we call a strict liability offence, you would still be guilty of the offence. And even though you might argue, sorry, I really didn't see the signs or I didn't mean to speed, the mens rea element is not required and you would still be guilty of an offence. Now, I have already mentioned very quickly in the past that the standard of proof in all criminal cases is proof beyond all reasonable doubt. And this is very important because criminal activity attracts loss of liberty at worst. So the prosecution and the jury, if it's a Crown Court case, have to be convinced that the defendant actually did commit the offence. Now, so the standard of proof for criminal cases is proof beyond reasonable doubt compared to civil cases, which is on a balance of probabilities. And the final point I need to make is that in criminal cases, the burden of proof, which simply means in court, who has the responsibility of proving a crime, lay on the prosecution. A case to confirm this is the case of Woolmington and the Director of Public Prosecutions in 1935, in which the defendant was so desperate to get back with his estranged wife that he took a gun to his mother-in-law's house and begged his wife or his ex-wife to come back. He said, "I'm serious about you coming back, and if you don't, I've got a shotgun with me." He pulled the shotgun out to confirm that he was going to kill himself if his ex-wife didn't come back to him, and he accidentally shot his ex-wife. The courts emphasised that it was the defence who had to prove that the gun went off accidentally, but that's where the courts finally confirmed that in any criminal case, the defence don't have to do anything. They don't have to prove anything. It's the prosecution who bear the burden of proof. So please remember that if you're asked for the name of the legal authority, which is the same as asking you for the name of a case that confirms that the prosecution bear the burden of proof, then it's the case of Woolmington. And this point also emphasises the provision we have in Article 6 of the European Convention on Human Rights, which firmly states that everybody has the right to a fair trial. And the right to a fair trial includes the prosecution showing that the defendant has committed the offence, and it's not the other way around. The defence do not have to prove anything. So that's a quick summary of Chapter 18 of the AS Law textbook. I want you to watch this video, summarise the key facts of Chapter 18, and then I'm going to do a short lecture after you view this video. Thank you for watching.